Welcome to Family Law Uncovered, a new series of podcasts from Thursfields Solicitors, one of the leading law firms in the Midlands.
My name is Jill Roberts. I am a Senior Associate in the Family Law Department here at Thursfields, who specialises in family law.
And my name's Olivia Lea, and I'm a paralegal who works alongside Jill.
We are both members of the family law team here at Thursfields who will be interviewing top experts from across the UK on a range of crucial subjects in this legal area. Today's episode is all about no-fault divorce and the importance of getting financial orders following a divorce.
So Jill, as you know, I'm fairly new to family law, having only been in the family law department for 6 months now. So I'm aware of the new no-fault divorce, and in fact, when I was studying, I even wrote an essay on it when the old law was still in place. But practically, I just haven't had much experience of it. So I'm just wondering if you could explain to me how it's different.
Yes, of course. So this has been one of the biggest changes that's come to divorce law in the last 50 years. That must have been quite frustrating for you, actually, to have wrote an essay on it and then you actually come to practice it and the law is actually completely different to what it was before.
Yeah, so I was sat an exam just before the new no-fault divorce law was coming in, and I knew that the new no-fault divorce law was coming in, and I knew that what I was learning wasn't necessarily going to help me.
Yeah, so obviously, to explain the difference, the change came in, and previously to that, if you wanted to initiate divorce proceedings to bring a relationship to an end, then you needed to show, first of all, that the marriage had irretrievably broken down, but then you had to show the irretrievable breakdown of the marriage by using one of 5 facts. Those 5 facts were either adultery, or that one party had behaved in such a way that the other party couldn't reasonably be expected to live with them, which is usually shortened to unreasonable behaviour. The parties had been separated for 2 years and both parties consented to the divorce, or both parties had been separated for 5 years and both parties didn't have to consent to the divorce. And there was also a fact of one party deserting the other party for a period of 2 years. Now, the reason that this came about, the change, is because previously, if parties did want to get divorced, they were having to either be separated for a certain amount of time, or they were having to use blame, such as adultery or unreasonable behaviour, if they didn't want to wait for that 2-year period. Now, this wasn't getting parties off to a very good footing when they were trying to resolve other issues that are involved in divorce, such as resolving the financial matters between them. And if they had any children and needed to sort out the arrangements for them, it wasn't getting them off on a very good footing in terms of actually resolving those issues, because they were quite often would be focusing on the issues that they were raising in the divorce with regards to adultery or blame or unreasonable behaviour, which require blame. And this then didn't put them, when they were trying to sort out the finances, that would be carried then into the finances and the children matters.
And which fact did you find was used the most?
If it was either usually unreasonable behaviour or 2 years separation, and usually the 2 years separation would have been used if the parties just didn't want to blame each other, and that required them to have to wait, and that had implications as well for the financial matters, with them having to, rather than go and get a full financial order at that time, which you can't get until you issue divorce, they were having to consider separation agreements. So that's one of the reasons that the change came about.
I can imagine that in children matters, if one parent was blaming the other parent, that the children would get dragged into the middle of it, and the parents would almost be trying to turn the children against one of the other parents. Whereas if it was more of an equal footing, you wouldn't necessarily have that problem.
Yes, I mean, it wasn't, as I said, it wasn't getting parties off onto the best footing, because you can imagine if they were using unreasonable behaviour and which required one party to blame the other, the other party might not agree with that, or might not, think that was reasonable for the other person to say that. And then when you're trying to resolve other issues, that's still in their minds. So,
do you think it was made a bigger problem because I mean, the most sensible thing to do on a divorce is instruct a solicitor, but it means that this unreasonable behaviour or blame was coming from a third party. And even if they had spoken about it beforehand and said, look, we want to get divorced quickly, we're going to put forward unreasonable behaviour, that even though they may have spoken about that, is what they were going to do, when it comes from a third party, it has a different tone to it.
When you say third party, do you mean friends and family that they were talking to about it, or?
No, I mean correspondence from a solicitor.
Oh, obviously that can have an impact in terms of how people react to it, but ultimately that's why the change is, because of all of those reasons. Because you could have that correspondence that came from other parties citing what they were going to put in those divorce petitions, and it had the same effect.
What has changed?
So the changes that have come about are, in a nutshell, that you no longer have to actually use those facts. In fact, you can't use the facts anymore when you are going through a divorce. So now, if you do want to issue divorce proceedings, the only thing that you have to say to the court is that the marriage has irretrievably broken down. Either one party or both parties are of the view of that, and that is all that you have to say to the court. So it removes the period of time that you would have to be separated from, and it removes any blame needing to be assigned to either party for the marriage having broken down. This can obviously make things more amicable. It makes things less stressful and less hostile, which can be very damaging to families. As I said before, this is one of the reasons that these changes have come about. Another key change is that previously it was only possible for one party to issue a divorce application, so it would be a sole application. There's now the possibility that if parties agree, they can do a joint application to the court. So both parties say to the court that they both consider the marriage to have irretrievably broken down, and a divorce petition is drafted where both parties are the applicants and both parties sign it. So it's coming jointly from both parties. However, there is still the option that if one party doesn't agree, that you can still do a sole application, whereby if one party has concluded that the marriage has irretrievably broken down, they can still issue the divorce proceedings if that's what they wish to do.
So what about the terminology? How has that changed? Because I know that the old terminology with decree nisi and decree absolute, people didn't really know what it meant.
Yeah, I mean, I think they're still pretty fairly common terms in terms of people still do sometimes know what they're meant, but what their courts have done is they've tried to make it more user-friendly. So what used to be known as a decree nisi is now called a conditional order, and what used to be called a decree absolute is now called a final order.
So does it take any longer now?
I wouldn't necessarily say that it takes longer. As I'm sure a lot of people are aware, there have been significant backlogs with the courts since COVID, and they have now introduced a online portal that you can issue the divorce. And there have been some minor hiccups with that, but generally if it works well, and it has sped up the process. However, the only other change that has now been implemented is that they have now put in a 20-week period from the divorce petition being issued to you being able to apply for your conditional order. You have to wait for a 20-week period. One of the reasons that this was implemented was that as they have removed the need for a period of separation, and some people suggested that may make things easier to get divorced, they've put that time period in for a period of reflection for parties to have before they have to take any next steps.
I suppose it stops people from making spontaneous decisions to get divorced.
Yes, that was an element of the reasoning behind that. I think probably most parties, by the time they've issued a divorce petition, in my personal opinion, have already reached that conclusion and given a lot of thought as to that's the process that they want to go down, but it also gives that additional period of reflection, as you say.
So under the new no-fault law, how many divorces have you completed, or how many have you got going at the moment?
I'd say I've probably got about 20, 25 at the moment that are in the process and have been issued. Unfortunately, I do have some that were issued prior to the changes and are still going on because of some of the delays that I talked about earlier in the courts. But I say probably about 20 to 25. I haven't actually got to the final order yet with any of those, mainly because a lot of those were resolving finances as well. And it's usual that we would resolve those issues before we would apply for the final order. So I haven't actually got to that stage yet. But yeah, that's probably me on my own. But Thursfields as a whole will be dealing with a lot more than that.
So what happens if the husband or wife doesn't agree to the divorce? What can they do to stop it?
Well, actually, that's another change that's come in. If a husband or wife don't agree with the divorce, they don't want it to process, actually now there is little that they can do. Previously, you used to be able to defend a divorce, which would make things very costly for parties, and it would increase the time that it would take. And again, as I said, it would increase the animosity. And ultimately, most parties, even if there was a defended divorce, in most circumstances, they would end up getting divorced. But as of April, they have taken that away. And the only grounds that you can actually defend a divorce now is if you're saying that the courts that it's been issued in, so here would be England and Wales, if you're saying that the courts in England and Wales don't have jurisdiction to deal with it and it should be another country that deals with the divorce, that parties can defend on that basis. Or if a party was trying to say that there was never a valid marriage in the first place, then they can obviously defend a divorce on the basis that they're saying that there was never a marriage in the first place. So they're really the only circumstances now that parties can defend a divorce. If both parties, like I said before, you can do joint applications, but obviously if one party is objecting to it, it's very unlikely they're going to do a joint application. Yeah. So in those circumstances, we'd usually say that there would need to be a sole application made. And if they are going to be really difficult, sometimes what can happen is that they will just ignore the proceedings in the hope that either it will just go away or that by being awkward, they won't be able to progress the divorce. But there are things that you can do to get around that. And that's not really changed from what it was before. What you would have to do is actually serve them with the papers and show the court, usually by personal service, that they've had the papers, but they're just ignoring them. And then the court would allow you to continue. There are some circumstances where you can apply to the court for what's known as deemed service. So if, for example, a party's admitted that they've had the papers and they are just ignoring them and you have some evidence of that, you can apply to the court to say, can you deem service? And you can sometimes, in some circumstances where, for example, the other party just cannot be found, despite your efforts to try and find them, you can apply to the court to dispense with service. There can also be implications in terms of costs if parties are uncooperative. So if one party's costs are increased because they have to personally serve them, then sometimes you can apply for cost orders as a result of that. That has been another slight change as well, in that you could apply for cost orders in general because there was the elements of blame that was still involved in the proceeding. So if there was unreasonable behaviour, there would be negotiations about whether or not the other party, the respondent, should pay some of the petitioner's costs with regards to that. But that's no longer, because of the blame's not there, that's no longer there. But if a party is uncooperative or is being difficult, then there is still the possibility to be able to do that.
So what happens if somebody's in prison? How do you go about serving them then?
Well, it's funny you say that, actually, because I had a case recently where there was a husband who was in prison. In this particular case, we managed to find what prison he was in, and we wrote to him, and he did actually cooperate. But there may be circumstances with that, mate, where you may apply for to dispense with service given the circumstances. But in that particular case, he actually cooperated and filled in the forms that we needed.
So what about if somebody's just gone missing? You don't know where they are. They've just fallen off the face of the earth. what do you do then?
Well, you'd have to take what the court consider to be all reasonable steps to try and find them. So, for example, you can do searches with tracking agents, for example, to try and find them. If you know there's family and friends nearby, you can sort of use those to try and track them down. But if you can show the court that you've exhausted all possible options, then you could that would be a circumstance where you could apply to court to dispense with service.
Obviously now there isn't the option for anybody to vent blame or perhaps hurt through divorce proceedings. Have you found that because they don't have that outlet to vent how they're feeling, that it's now coming out more in their finance or children proceedings?
That's a very good question, actually, Olivia, because obviously divorce is a very emotive subject, and there are often a lot of emotions involved. I mean, my personal experience is that I've not come across it so much so far. It's most of my clients that I've had have embraced the change and seen it as positive. Most of the clients that when I have explained the changes, still aren't aware of the changes. But most of the time, when I've explained that to clients, they do feel relieved that actually that change has come in, because they have certain anxiety around either having to stay married to somebody that they didn't want to for 2 years, or having to go down the route of blaming them when potentially they're on, fairly good footing with each other and don't want to jeopardise that. So my experience so far is that actually it's mostly been positive, but I can see that there would be a risk for that to happen, because you quite rightly said people don't have that outlet to vent and sort of feel as though they've got that off their chest. Conduct and behaviour, so in particular in financial matters, is something that is used very rarely. But I can see that there could be potential for parties to want to raise this more and more if they, as you quite rightly say, have felt that they haven't been able to channel that through the divorce.
Or they might feel like they just want it to be acknowledged by the court in some way.
Yeah, exactly. Yeah. So I can see that there potential for those issues to start getting raised more in other areas. I mean, all of our lawyers at Thursfields are all members of Resolution, which is an organisation where you sign up to a code of conduct, and that code of conduct is to try and reduce as much as possible all the animosity and conflict. So all of the all the Thursfields lawyers here are all signed up to that. So we do try to encourage that.
And in terms of costs, I know that we've touched on it, but if there's less animosity, do you find that there is less costs involved for the client?
Yes, definitely. If you're able to resolve the conflict in any area quicker, then obviously that's more cost effective for all parties involved, whether that be our clients or the other side, because ultimately it's all coming out of the same pot.
So you've talked about finances, and one thing I've learned is how important it is to resolve the matters when you go through a divorce and get this drawn up into an order, particularly as divorce is becoming more accessible.
Yeah, you're absolutely right, Olivia. It's often a common oversight that if there's no assets of a marriage, or if parties have sorted the assets that they did have from the marriage out themselves. So, for example, if they've sold a property and that's what they considered was the only asset of the marriage and divided it, parties sometimes think, actually, I've done the divorce, I've got my final order now. I don't actually need another order to deal with the finances. And as I said, that's quite a common oversight for people. And it's very important that people realise that actually you do need an additional order. What a lot of people don't realise is that when you do get your final order in the divorce proceedings, this doesn't actually sever the financial ties that you have with each other arising out of the marriage, and it doesn't actually go on to protect any future assets that you might have, such as inheritance, or, for example, fingers crossed, you were to win the lottery. When parties do get divorced, the courts have power to deal with parties' capital, pensions, and income, which is often something that people also don't realise, is that actually you need to sort out all three of those areas. And sometimes people, when they're discussing themselves, if they haven't had advice will just, for example, sort out the capital and ignore people's income or ignore people's pensions, and it has to be considered as a whole. The only way that these claims can be ended is by a court order. Now, that court order can be by consent between the parties, or if they can't agree how the finances should be resolved, then it can be imposed within court proceedings. If the parties don't have any assets, as I mentioned earlier, then it may be appropriate for them to have an order which simply says that they will not make any financial claims off each other now, but they can't make any financial claims off each other in the future. It's what is commonly known as a clean break. And what that does is protect those parties that if they were to go forward and get any future assets, the other party wouldn't suddenly all of a sudden be able to start to claim on those.
So that's really great, Jill. Thank you for giving us such a great overview. Would you be able to just give those listening at home 2 key points that they should take away from our podcast?
Of course. I mean, the one key thing is get advice early so that you can go forward making informed decisions. But in terms of the divorce, the key thing to take away is that there is no blame required anymore and there's no period of separation, just that the marriage has irretrievably broken down. And if you are going through a divorce, then it's very important to consider the finances and to make sure, even if there aren't any assets involved, that you get that financial order as well, either expressing what is going to happen with the finances or getting your clean break to protect any future assets that you may acquire. You've been listening to Jill Roberts and Olivia Lea. Hopefully you found our discussions on this topic insightful and have found it useful. If you're dealing with a family relationship breakdown and would like more advice, you can contact us directly on our website. We will be back next month with Shane Miller, who will be joined by Chris Walklet from Bishop Fleming to discuss expert witnesses.
Family Law Uncovered, an original podcast from Thursfields Solicitors. Thanks for listening.